All right, Mr. Parrish, are you able to hear me okay?
Yes, sir. I can't see. Excuse me. Connor, can you help me out here?
Yeah, I'll be able to help you just a second. So not someone. Hold on. One second. We'll get you some. Hey, Mike. Warm me up.
So the latest record we have is that they got these paperwork for us.
Oh,
Okay,
there it goes.
Mr.
Yep.
Parrish, you can hear me okay?
Yes, Your Honor.
We're good now.
All right. We'll go on the record as People versus Andrew Parrish. This is case number 2455317. The record should reflect Mr. Parrish is appearing today by video from Schoolcraft County Jail. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Shoestring on behalf of Mr. Parrish.
And I believe this is a situation where Mr. Parrish has entered a guilty plea, but we haven't been able to get a PSI done. Is that correct?
It is.
That is correct,
That
Your
is
Honor.
accurate.
Mr. Haven, are you the Haven?
Yes, Your Honor.
How do you want to proceed?
Well, I believe he's serving a jail sentence. It might be, I'm not sure how long, but I can get in contact with that jail and get the interview completed. I don't know if he completed his information packet or not, but if not, we can probably.
Yes, I did.
I
I sent that in a while back, at least over a month, 2 months ago, I would think.
Okay. Yeah, I did get it back. So I will call the jail and get an interview completed.
Okay, and then, Mr. True, should we just have this set for sentencing again? Set it.
I think that's the only thing that we can do. I was contacted by Mr. Parrish's attorney up there. They let me know he was in the jail. That was about a week or so ago. So we did everything we could to address it, but it is what it is.
Do you know what his current sentence is there?
I don't. Mr. Parrish, do you have an out date? Do you know when that is?
I was sentenced to 180 days.
Okay, so fair to expect that you're still going to be there in the middle of January?
Yes, sir. Probably till at least February, I would expect.
Okay, so Mr. Parrish, we're gonna reset your sentencing hearing. Mr. Haven will be in touch with you there prior to that. The only matter that's left is you do have the right to have that sentencing hearing in person here in Crawford County. And if you wanted to exercise that right, I would sign an order to have you transported here to Crawford County for that purpose. You can waive that right and we can have that hearing by video like we're doing today. Do you know how you'd like to proceed on that?
I would like to proceed in video, and I was also wondering if it would be possible, if it's okay with you guys in this jail, if I could just possibly serve one sentence with you guys in this jail up here, possibly.
Yeah, so Mr. Trush and Mr. Haven are hearing that. So that's something that you can discuss with them further, and then we'll talk about that at sentencing.
Okay.
But the court will have the record reflect that Mr. Parrish has waived his right to his sentencing hearing here in Crawford, and we'll have that done by video. So Ms. Pope, if you can prepare it read by video for that.
Yes.
Ms. Coke, anything further we need to address on this? Yes.
No, thank you.
Nothing further.
Mr. Parrish, do you have any questions at all?
No, Your Honor.
Okay, thank you. That's all for this hearing today, and the court's going to disconnect at this time.
Thank you.
Is Mr. Mallory here?
I have not seen Ms. Mallory come in yet. I can check outside. Mr. Marshall just came in.
Okay. We'll pick up Mr. Barshaw's in a second, but you can just check and see if Mr. Mallory is out there.
Mr. Fahey?
So this is yes. Oh, Stefan is the last. I'm sorry.
Your Honor, I just checked the lobby, Stefan is not.
So we'll call People versus Mallory Stefan, case number 245348. Counsel.
Eric Hope on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Ms. Stefan.
This matter was set for 2:45. It's now 2:50. Ms. Stefan is not present here in courtroom today. Have you had any contacts with her, Mr. Trush?
I have. I spoke to her on the phone last weekend, met with her in my office last week. Surprised she's not here.
Ms. Koch, she can take any position.
Would ask for a bench warrant.
Right. Typically, when there's been contact with the attorney, I would simply set up for a show cause, given the nature of the charges in this case. I've had cases with this and in the past, I have concerns for public safety. So I agree with Ms. Koch. I think it would be appropriate to issue a bench warrant for her arrest, particularly because she's had contact with her. Should have known about her. So Ms. Koch, once that's presented, we'll sign that. We'll proceed further on this Stefan's case when she's arrested. Mr. Barshaw, if you'd like to come forward, please. File number 225126 versus Barshaw. Recommended by Mr. Barshaw. Today.
Eric Hope on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Barshaw.
This is set for a probation violation here today.
Well, I think actually there's a second set of violations that the court has to arraign him on. And then I think we have a resolution for the court.
Were those new violations?
Signed on November 22nd. 5 count.
Okay. Mr. Trush, have you had an opportunity to go through those with Mr. Barshaw?
We have, Your Honor, and they form the basis of new charges that are coming out of Otsego County, although I don't believe he's been arraigned on yet.
Okay. And have you been able to advise Mr. Barshaw of his rights with regard to the alleged violations and the maximum possible penalties?
I have.
Mr. Barshaw, you understand the alleged violations as a result of warrant that was issued on November 22nd. How does Mr. Barshaw want to plead to those at this time?
So, Your Honor, we're going to be tendering a no contest plea to the violation for possessing methamphetamine and the remainder of the violations in both sets of allegations would be dismissed. The purpose of the no contest plea is obviously he has some criminal and potential civil liability in Otsego. Again, I've been in contact with Mr. Roller there. The charges we expect to be coming down in the near future. But I have an affidavit of probable cause for the court to provide a basis for that. Additionally, I have for the court a correspondence from Great Lakes Recovery Center indicating that Mr. Barshaw has a bed available for him tomorrow in their residential treatment facility in Marquette.
Mr. McDowell, is that a correct statement of the plea agreement?
Correct, Judge, would be count 1 of the last set of violations and dismiss all the others.
Okay. Mr. Barshaw, have you had an adequate opportunity to speak to Mr. Truth about this agreement? Is that how you want to proceed?
It is.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Mr. Barshaw, you understand that you do have the right to have a hearing as to whether or not you did violate the probation? Yes. And you understand that by pleading no contest today that you're going to be giving up that right. Also, by pleading no contest, rights that are a violation of your probation. Because this is a non-technical probation violation, that subject you to the maximum possible penalty on your underlying charge, which is up to 10 years. You understand that? I do. With that in mind, what is your plea to one of the alleged violations? Guilty. Or no contest? No contest. Has anybody threatened you with anything to get you to enter this plea today? Has anyone promised you anything other than said correct? Is it your own free choice to enter this plea? Yes. And I've reviewed the probable cause affidavit that was submitted and stated November 25th, 2024. And then I believe my view would form a basis for finding that Mr. Barshaw did violate his probation by violating state law by being in possession of methamphetamine. So the court will admit that affidavit as court exhibit 1. The court finds that otherwise the plea is knowing and voluntary. The court satisfied that there's a factual basis, so the court will accept the no contest plea to the alleged probation violation. In terms of sentencing, Mr. McFelda, are you going to be seeking jail time on this charge?
Judge, I think we just need to set this,
Set it out.
set it for sentence.
So the court will set this for the sentencing date. In terms of bond ending that time.
Your Honor, I think bond was already set and then he posted that.
Yeah, and the other violations, right? The first set.
That's correct, Judge. I'm actually surprised. I didn't even know he was out of jail. Anticipated he was going to be in jail today. I'm surprised he hasn't been charged in Otsego County yet. Don't know exactly what's going on out there. I was under the impression that that would have been, charges would have been already done before he got out of jail here. He was sitting on some sentences out of district court. And I think he got like $1,000 bond on just that, on the previous violations. You know, I think that some additional bond means he just pled to non-technical violation that could expose him to, you know, up to 10 years in prison is would be appropriate.
Mr. Drew.
So, Your Honor, a few things I think the court should consider in regards to bond. Again, I would indicate that he has posted a bond. He's taken it upon himself to secure a bed in a residential facility. Actually, he secured the bed approximately a week or so ago when we had started to formulate what we were going to do at this hearing. So he was able to post the bond, obviously. I would ask the court not to disrupt that. I would also point the court to, as the court looks at how to sentence him on the non-technical violation, the court still has to consider the guidelines in his underlying offense. His guidelines were 0 to 9 months on the underlying offense. He already has credit for about 5 to 6 months against, you know, that 0 to 9 month range. Obviously, that doesn't necessarily mean that there's not potential jail time that's going to happen there. But given the circumstances and given that he has posted a bond and he has secured a bed, I would ask the court not to disrupt that. And just in regards to what Mr. McFalda said, my understanding from talking to Mr. Rolla in Otsego County is that their office authorized the charges late last week. So my guess is that they're waiting on an officer to swear to the warrant and those types of things, you know, before it can be processed.
Mr. Barshaw has been on probation since last July. Is that right?
Yeah, Judge, just going back, he was sentenced last July, credit for time served. I think he had 137 days, and I never seen Mr. Barshaw after that. He's been an absconder since till he was arrested. When was he arrested? On November 20th. I know his name's been out and about. I know the drug team up there has been come across his name several times. They were familiar with him. That's actually how they arrested him. He was, you know.
Okay, so he didn't, since July, he hasn't complied with probation?
No, he's been an absconder since he got out of jail in July. He he gave me an address, somewhere in UP, which was a bad address, and I never heard from him, so.
Well, I'm, in light of the plea today, the court's gonna revoke the previous bond. Or that you permitted the custody of the county shot. In light of that, I think allowing you to go to Marquette at this point, not a good idea. I certainly will consider treatment as part of a sentence in this case. But at this point, I don't have any confidence that you would appear in court or in future dates based on what's going on so far. So
I would note, Your Honor, since bonding out, he has been in touch with my office and did appear here today.
okay, and that's great. But
I understand.
yeah,
Any cancellation, just go down from us and have it, let's make sure I can make it to treatment and, we've got a actually agreement on what I'm supposed to be doing to get all of this behind me, because God's honest truth, I don't ever want a reason to turn my wheels to the right coming off the expressway between the 270 and the 251 ever again. I don't actually ever want to come south of the bridge unless I have to be here for court and she will drive me. And I'm almost 40. I'm a drug addict and I need help more than I need anything. So I'm gonna end up killing myself with getting high.
yeah, I don't disagree with any of that. And like I said, I think as part of the sentence, we'll take a real hard look at rehabilitation, in terms of treatment. But at this point, from the court standpoint, I need more than just agreement with your family that you're going to appear for court based on prior history. So again, the court's been orderly to be held without bond and sentencing. So that must be right now.
And we just asked the court to set it at the first available date for sentencing.
And we will. Had contact with Mr. Maher.
I did speak to him on the phone last week.
Court will call People versus John Maher, case number 245354. And standard was set for 3 o'clock for the record. But it's now 5 on my clock here. Mr. Maher does not appear to be present.
Your Honor, can the court check if he may be on Zoom? I do see on the 6th, there was a request submitted for Zoom.
I can see that. He is not on Zoom at this time. I'll pass this matter for now. They may be having some technical difficulties. Connected, so I will get that here.
Judge, Mrs. Van is here.
Oh, okay.
If we could just take a brief break so I can try to contact Mr. Maher and talk with Mr. Van.
Sure. Yeah. It's 3:05. We'll come back on the record at 2:15. Maher, you're gonna need to connect your audio on your device there.
Hello? Hello?
Thank you, owner. Thank you, owner. Here. You got to move over.
And over here, what,
Yes, you want it.
let's see. Oh, what background?
Okay, there we go. All right, Mr. Maher, are you able to hear me?
Yes, sir.
Okay.
Can you hear?
All right, we're on the record now in versus Maher. The court, the record should reflect Mr. Maher's presence today by Zoom video. Mr. Trush, can you tell me the status of this file today, please?
Yes, Your Honor, I had an opportunity to discuss this with Mr. Maher last week. The prosecutor has made an offer. If Mr. Maher admitted count 1, the possession of methamphetamine, counts 2 and 3 would be dismissed. Mr. Maher did intend to take advantage of that.
Oh, is that a correct statement?
It is, it includes the forfeiture of the weapon.
And then that is required by statute.
Okay, Mr. Maher, were you able to hear that?
Yes, sir.
Okay, and is that how you wanted to proceed today?
Yes, sir.
Okay, so under the terms of the plea agreement, you're gonna be pleading guilty to 1 count of possession of methamphetamine. Is that your understanding?
Yes, sir.
Okay, can you raise your right hand, please?
Yes, sir.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Meyer, are you currently on any kind of probation or parole?
No, sir.
And you understand that by pleading guilty to possession of methamphetamine, that's a felony that carries with it a maximum possible penalty of up to 10 years and or a $15,000 fine?
Yes, I am aware of that.
Okay, with that maximum possible penalty in mind, what is your plea to that charge today?
It's guilty, pleading guilty.
All right, I'm gonna go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yeah.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you'd have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are guilty?
Well, it was in my work truck, yeah.
Okay, yes?
Yes,
Okay, so this happened back on September 28th of this year, is that correct?
yes, sir.
On that day, were you here in Crawford County?
Yes, sir.
Okay, you said on that date you had some methamphetamine in your work truck, is that what you said?
Unfortunately, yes, sir.
Okay. And did you know what that substance was?
Believe it or not, I know what methamphetamine is and what's about. So I do know what it pertains to. I mean,
Okay, so yes, you knew that it was methamphetamine?
yes, when it was believable. Yes.
Well, I'm just asking whether you knew it was methamphetamine or not.
Well, I didn't even know there was methamphetamine in there, but I guess with the officer finding it, then possession's 9/10. So I
Right,
have to
so
take responsibility for it.
Mr. Maher, I'm asking a very, very simple, very straightforward question, okay?
Can you hear
Still
me?
there? Yep. Did you know that that was methamphetamine or not?
No, but I can't. I lost audio.
Mr. Maher, can you hear me?
Can you hear me?
I can hear you. Can you hear me?
Can you hear me?
Yes.
Can you hear me?
Yes. Mr. Maher, can you hear me?
I don't know why I'm fucking listening to anybody.
Are you guys able to hear me?
Hello?
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 Hello? Hello? Hello?
Yes, are you able to hear us?
Hello? Can you hear me? Hello?
Mr. Trush, what do you want to do here?
Well, I don't think he can hear us. My proposal will be that we set it for an in-person plea taking
Yeah.
in a month's time.
Oh, any objection to that?
No.
All right, I'm gonna ask that you communicate, he's obviously not able to hear what we're doing here, so if you can communicate with him, the court will set for an in-person hearing.
What do they say down there?
For his next couple of days.
Well, I can't even look.
I don't know what happened to it. Hello? Hello?
Versus the fan. 45348.
Yeah, tell them.
Select that Mr. Vance is present here in the courtroom. Ms. Vance, the reason why you weren't here for your court on time today?
I just thought it was Sunday.
Not today was Sunday.
Yeah, I had a calendar set on my phone, but I didn't hit it.
I was just ready to sign a bench warrant for your arrest, have you arrested and brought before the court, so it's important for you to be here on time. You understand that? Mr. Trush, how do we want to proceed with this file today?
Thank you, Your Honor. We would ask that this be docketed for a trial I suspect the one-day trial would be sufficient, then I'd ask for a final status conference the month of trial.
So, length of trial.
Just checking. I would agree. I think we can do it in one day. I may be filing a 76827C motion. I'm gonna review her prior history before I file that.
Okay, and has there been a plea offer in this case?
There was, the plea offer was withdrawn when she ran the preliminary examination, and there's been no further plea discussions. They said it was gonna go to trial.
So, and do you need any particular period of time to be ready for trial in this case?
No,
Mr. Church?
No, Your Honor, but I would, based on the prosecutor's statement, suggest some period of time for motion practice.
I think it'll be probably 90 to 120 days out. So that should give us enough time. We'll set it for a one-day jury trial. I will set it for a final status conference, so folks, that'll be the motion cut off. To the extent you're going to see any type of motions, and same for defense. To the extent there are any further plea discussions, that'll also be the plea cutoff date as well. The court will send out notice of the date and time of the final status conference as well as the trial. The court is not going to sign the bench warrant since Ms. Stefan did appear today. But Ms. Stefan, it's important that you stay in touch with your attorney so that you're prepared for that time.
Yeah, I would have been here on time. I usually am. I just didn't know.
Yeah, just make sure you stay in touch with Mr. Church, okay? Ms. Koch, anything further on this file today?
no.
Nothing further, thank you.
Okay, thank you, that's all for today. People versus Bradley, case number 245301.
Sierra Cook, I have the people.
Thank you, Honor. Jason Thompson, on behalf of the defendant,
The record should reflect Ms. Bradley's present here in the courtroom today. We had this set following a hearing earlier this month. Mr. Trush, or I'm sorry, Mr. Thompson, how are we going to proceed today?
Yeah, I believe, so Ms. Bradley's out of the hospital. I believe she has to accept that contest plea we done at the last court hearing. That would be a no contest plea to one count of 4-year felony honored with HYTA as part of the plea agreement. Or did not determine she's eligible for HYTA. She was honored.
That is a correct statement. The offer is a costing for immoral purposes. The PAT code on that is 750.145A-A.
That's maximum penalty of 4 years.
Yes, 4 years and or $4,000. It's an F-grade felony.
All right, and Mr. Thompson, one of the discussions we had with Ms. Bradley last time was her ability to you had discussions with her since then.
Yes, I spoke to her before court. I text messaged her with the hospital. She indicates to me it's her intention.
Based on your discussions with her, do you have any concerns regarding competency?
I have concerns that I believe she's competent.
All right, so Ms. Bradley, have you had a chance to talk to Mr. Thompson about this?
Before court started, yes. We have talked about it in the past, but again, I was in the hospital and I wasn't really fully coherent of what I was saying. But today, when I talked to him before court, I was, and I am fully confident in the decision I made of doing the probation stuff. That one.
All right, so you've had enough time to talk to him to feel like you're ready to go forward.
Yep.
Is that how you wanted to proceed?
Yes.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Lower your hand. Ms. Bradley, are you currently on any kind of probation or parole?
No, Your Honor.
And as Ms. Koch indicated, you understand that by pleading guilty to this charge, which is accosting a minor for immoral purposes, maximum possible penalty you could face would be up to 4 years and or a $4,000 fine. You understand that?
Yes, Your Honor.
And Your Honor, it is no contest plea.
Okay, gotcha.
Thank you.
And so in light of that, what is your plea to this charge today?
I would say no guilty, but I'm feeling guilty.
So your attorneys indicated this is a complete no contest. Is that how you want to proceed?
Yeah.
I'm going to go through your rights with you to make sure you understand your rights. Okay. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove that you are guilty beyond a reasonable doubt. You have the right to have any witnesses against you appear at that trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at a trial. You have the right to remain silent during the trial, to not have that silence used against you, and the right to testify yourself if you want it. Understand those rights?
Yeah.
Tell me one of the rights that you're going to give up by pleading no contest today.
Don't have an answer.
All those rights that I just told you about. Now, you know what's going to happen to those rights by you entering this plea today?
No.
Well, Mr. Thompson, I don't think I can accept the plea. She needs to understand that you waive all of those rights. So at this point, I think I would have to put her out of the exam. I don't know if this is a matter of competency or just a matter of comprehension. So what's your counsel, what's your position?
I think the court is correct procedure.
Your Honor, I would defer to the court.
Defer to me. I know I have the discretion here. I'm asking for your position as the prosecutor.
I've actually never spoken to her other than what I've heard in court. It doesn't sound like she's understanding the questions that are being asked. I don't know if it's because she doesn't understand the way they're being asked or she just doesn't understand what's going on. So I think if we have to order a competency exam, I think that's appropriate.
Okay, so, Mr. Thompson, I'll ask you to prepare that order. We'll have the exam, I mean, in light of her treatment, regardless of what's going on today. So, Ms. Bradley, what's going to happen now is you're going to be contacted by set up an interview with you to talk to you about your mental state. Okay. It's important that you follow up with that. It's importantly that you stay in touch with Thompson.
I do have a telehealth appointment this week, Thursday. I don't know if you need to know.
I don't think you need to know about that. You need to follow up with that. Obviously, that's important for you for other reasons, but make sure you stay in touch with Mr. Thompson. Okay. Otherwise, you're going to be continuing on the bond conditions that you have. So you make sure you follow all of those as well. Okay. Mr. Thompson, further to that.
Alexis, do you still want the court to use 103 Crestwood for mail, or do you have a different feeling address?
I do not have a different mailing address right now. So I guess I have it.
Nothing further.
All right, that's all for today. People versus Jason Ball, case number 245343.
Sierra Coke on behalf of the people.
Thank you, Honor. Jason Thompson, on behalf of the defendant. Your Honor, there is a plea offer in this case for Mr. Ball to plead guilty to attempted resisting and obstructing. That's a one-year misdemeanor. He wishes to accept that plea offer.
That is a correct statement of the offer.
Mr. Ball, have you had a chance to talk to Mr. Thompson about this plea agreement?
Yes, sir.
Is that what you discussed, pleading to attempted resisting and obstructing?
Yes, sir.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Wolf, are you currently on any kind of probation or parole?
No, sir.
And you understand that by pleading guilty to attempted resisting or obstructing, that is a misdemeanor that carries with it the maximum possible penalty of up to 1 year in jail.
Yes, sir.
With that in mind, what is your plea to that charge? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent or proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you during a trial to question those witnesses. Right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial and to not have that silence used against you. The right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
Tell me what will happen to those rights by you pleading guilty.
If I plead guilty, I no longer have those rights to do any of the above.
That's correct. Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
It's your own free choice to enter this plea.
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
This happened on September 14th of this year, is that correct?
Yes.
On that date, did you come into contact with a deputy from Crawford County?
Yes, sir.
Did that occur here somewhere within Crawford County?
Yes, sir.
At the time, was that officer wearing his or her uniform?
Yes, sir.
Did you know that that officer was there performing their duties as a police officer?
Yes, sir.
And what happened that, did you fail to comply with some orders? What?
Yeah, things were aggressive right off the bat between the two of us, the talking, arguing back and forth. He told me to come, I came. Told me to put my hands on the car, I did. He told me to put my chest against the car, and I did.
Was that during the course of an arrest that was being made?
Yeah.
Maybe you can
answer
answer
legally. Yeah, so legally, he had not told you you're under arrest yet, is that correct?
Correct.
All right, but he was giving you orders as part of his investigation to a 911 call.
Yes.
Is that
All
sufficient?
right, Ms. Coe,
I believe that's sufficient.
Ms. Coe, are the people aware of any threats, promises, or inducements?
No, yeah.
No, nothing else.
Ms. Coe, are the people satisfied that the court has complied with statute and court rule in taking this plea?
Yes, Your Honor.
Mr. Thompson?
Yes.
Mr. Coe, the court finds that your plea is knowing, voluntary, accurate, or satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. In the meantime, you're going to report. It's also important in the state of
When do I meet with the probation officer?
Right,
Yeah, you're going to be
right behind you.
Yes, sir.
2, 3, 4.
Yep.
People versus Green. Green, case number 214950.
Miracle can be up to the people.
They're void of hearing on behalf of
Set for a probation violation hearing today, I believe, is that correct?
the Yes,
Why are you appearing for Mr. Gurmurthy?
I am.
How does Mr. Green want to proceed?
It's my understanding there's been an agreement to adjourn this probation violation hearing due to Mr. Green is supposed to be sentenced in district court on January 7th. So I believe that we're waiting on the outcome of that sentence.
And this,
Mr. McCall, I know we kind of started without you in the room there.
I caught that, Judge. That is correct. Mr. Green pled in district court. He's been sentenced on the 7th, and I would like to see what happens on that case before I make any further decisions on his violation here in this case.
Mr. Green, do you have any objection to that?
No, I don't.
Can we do this on the 20, can we set it on the mid-motion day and then I'll,
Yeah,
monitor what sanction he gets on that and then make a decision on.
okay, so we'll set it for the then motion day. Mr. Green, just make sure you stay in touch with your attorneys, okay?
Sure.
All right, thank you. Versus Brooks, case number 245044.
You're supposed to be after the people.
Mr. Brooks,
Yes.
Mr. Brooks.
Thank God. Jason Thompson will have to.
You're supposed to be after the people.
So this is the date and time set for sentencing in this matter. Thompson just, and so everybody's aware, I did receive a report. Was issued by the regional office in Alpena. Had a chance to review that report prior to the hearing today. So present reports. I just want council to be aware of that. Mr. Brooks, did you have a chance to talk to Mr. Thompson about the pre-sentence report? Go through that with him. Mr. Thompson, are there any additions, deletions, or corrections?
No, it's not.
Challenges this morning?
No challenge to the scoring gunner.
It's code. Do people have any additions, deletions, or corrections?
No, Your Honor.
Challenges to this morning?
No, Your Honor.
Yeah, people for allocation today.
This is a tough case because certainly Mr. Brooks presents as a sympathetic person. He has had a tough life, and I think there's one spot in that report that said he was dealt a tough hand. I actually agree with all of those things. The problem, and I don't know Mr. Brooks, we have defendants here that come in and out of the court on a regular basis. He's not one of ours. It appears from his criminal history that he is a Mayo repeat offender, and most of his criminal history is in Mayo. So I don't have much on way of background. I did read the report. I thought some of the things I saw in the PSI were concerning. You may be given a bad hand, but at some point you're making choices. The amount of alcohol he's consuming is never going to lead to a good situation. And I would think that Mr. Brooks, given his history and his mental health issues, would realize that. He's got a history of substance abuse. He's had some opportunities to do rehabilitation. I know normally it takes a few times. He is young. His guidelines are high because he's earned them to be high. I think that, a 13, 14-month sentence might be appropriate. I really hope that he gets his life together and that he doesn't continue being a regular member of the criminal justice system, but maybe a regular member of society. Thank you.
I agree with a lot of that. I know for the court, the compass narrative indicated, moderate risk of recidivism. Mr. Brooks does have some difficult background, some tragedies in his background. He's a gentleman. He's only attempted to have once, is my understanding. Designed to that program, but he's not someone who's to go through the whole program. He's not someone who sort of speaks the language of rehabilitation, who's been educated in that way. He is a young man who's very pleasant, very cooperative. One of the things I know through his biography is how much better he does after he's given some direction and some guidance. I think we see multiple times in the biography where he's, maybe homeless, maybe he is able to get on the right track. I think that's what I would hope for him. That's what I would think for him, is that I think he is pointed in the right direction. Moving forward with rehabilitation, I would hope that he could successfully stay on that path. He got off that path here clearly. I took responsibility for having that methamphetamine. I want the court to note that he was negative the next morning for the drug testing. So I'm hopeful that he's sort of arrested in the midst of attempting to relapse as opposed to be fully in the depths of it. So I would hope court would consider a sentence focused on jail rehabilitation. Thank you.
One question I have, Mr. Haven, I mean, do you know what the parole status is?
The parole violation is waiting because he did not post bond, so he's not available to the department. Once he is sentenced, he will be available and the parole sanction would be handed down once I finish the report. No, but this sentence would be consecutive to anything he receives regarding parole.
And are you folks here from Maya?
Yes,
What's your?
I'm the social worker for the Public Defense team. I'm the Northeast Michigan Regional Defender Office. This is our client.
Do we know what the status of the pending charges are there?
Those are resolved.
How did they?
He has been served.
Okay.
And so they, you know, it's my understanding that they want to see them be able to succeed. And they also saw that this half of the summary like we did for this court because of based on the charges. But they did see this history a little bit more than what they took that into consideration for that. So they're having this up what we could be facing today.
All right, so what happens here is what happens here. There's not other matters still pending. So I guess, Mr. Brooks, is there anything that you wanted to say?
Yeah, I need really help. I need rehabilitation help. I need guidance, good guidance. A representative, stuff like that. I really do know I really do understand my situation and where I'm at, my consequence of my actions, some of the issues. Really need help with my addiction and stuff like that. And now I'm trying. That's all I know.
All right, like I said, I read through the report, so I'm familiar with your background and your circumstances from the PSI as well as from the Defender's Office report. I'm aware of your past history, which does involve mostly drug-related charges. And I know that there's a lot of issues going on here. It's very apparent just from the report of past history, but also the additional information that was provided to the court. And I don't know what the bigger issue is, whether it's your substance use or the mental health issues, which one's driving the other one more. But it's apparent to me that if you're just left on your own, you're just not going to do well. You do need assistance. And I do see indications in there that you've done better. You do have help and some oversight. Looking at the guidelines here, it's 5 to 23 months, so the court will be well within the guidelines essentially prison, but it's a straddle cell. The court's well within the guidelines to sentence you to a shorter term of jail with probation. And in this case, based on, I just don't see if there's going to be any possible benefit to the community to send you in prison at this point. It's just not that's not going to help. If it gets to that point and we don't have other options, then that is what it is. But when we have another option available, it makes sense to me to at least try that option before we send to prison, because I don't think that's going to have a positive outcome under any circumstances. Whereas attempting a shorter jail term and probation with some oversight has the potential to at least have success. So when the guidelines allow for it, and in particular in your case where you could benefit from things like having a guardian, somebody to help you with your finances, having some mental health treatment, having oversight of probation, I think there's an indication that you do better under those circumstances than you would with a prison sentence. And I think that would benefit our community more than just sending to prison at this point. So, and ultimately, if it doesn't work, the court's got plenty of room under the guidelines to ultimately send you to prison if that's what happens. So I don't see that there's a lot of downside to this. I do see a potential for upside. So the court is going to, apart from the recommendation in this case, which is prison, the court is going to sentence you to 5 months in the Crawford County Jail. And I do want to note for the record that it's not just about your own situation. This wasn't a particularly serious crime. That's here in and of itself. I don't think all the different kinds of anything else. I say that as an aside for the record. So the court is going to sentence you to 5 months in the Crawford County Jail because of your parole status. You don't have any credit. We'll see what happens with whatever your parole sanction is. We'll see how that plays. The court is going to sentence you to 24 months of probation. The court is going to adopt as the conditions of the probation all the standard terms and conditions. The court is going to, it's usually a standard term or condition, but the court is going to order that you comply with any mental health treatment that's recommended to you. The court is going to include as the conditions of probation that you not use or possess any controlled substances. So you need to stay away from the drugs. The court is going to order that you participate in any kind of psychological assessments, anything that would aid in having proceedings to provide you with a guardian or conservator to help you with finances and help you with just the routine decisions of daily living. So the person is all of that part of your probation so that we have some oversight. Is there any other information you need, Mr. Haven?
No, since he is still on parole, he will be available to professional consulting services who are overseeing him as a mental health case. And they help provide with housing and getting him in touch with his mental health treatment. So he will have extra oversight in that regard, at least until July.
Okay. The court is going to order a crime victims assessment in the amount of $130, court costs of $325, attorney fees of $350, $68 state cost, as well as supervision fee of $30 a month while you're on probation. You do have the ability to seek an appeal of this sentence, Mr. Thompson.
Mr. Brooks, you're gonna initial this. It's not the same as filing an appeal, but the copies you keep are the ones that you use to file an appeal if you choose to do that. This is just gonna go in the court file to show. Yeah, so the order is clear. Yeah, I think Mr. Brooks should go to the whether he's ordered to or not, the court ordering that, and so with that after the jail time.
Yeah, I mean, that would be one of the terms of probation that you comply with any residential or outpatient. So recommended for him. I would include, a condition that he comply with the DHHS, any kind of services that they're providing that he comply with whatever they're asking him to do.
Would you allow him to go to treatment in lieu of some jail at the end of his sentence?
I think we need to do the 5 months. That's the lowest under the guidelines. So Mr. Brooks needs to serve those 5 months. But once he's released from jail, that's something that can be arranged through probation. Ms. Coke, anything further from this?
No, thank you.
Brooks, you're going to this now. Those are your copies. Versus Bollender, case number 225140.
Sierra Coke on behalf of the people.
Afternoon, Your Honor, Elliot Blumberg on behalf of Mr. Bollender.
This was set, I believe, to the statutory jail requirement.
That's correct.
Okay. And I believe has he been discharged from probation?
Not yet.
I have not.
Okay. How much more time do you have left?
It's pretty soon, isn't it?
If I remember correctly, it's April.
April, okay. Mr. Haven, you're supervising Mr. Bowman.
Yes.
I think was it you that requested this hearing?
Yeah, I requested this hearing. Well, Your Honor had stated that his sentencing, he was not ordered to jail at that time because of his health issues. The health issues have continued. He's had pacemakers installed and replaced, and he continues to have medical issues. And I just want to make the court aware. He's about 5 months from the end of his probation at this point. I just wanted to make the court aware. He hasn't served a jail sentence, and I'm not sure when he would be available.
Okay. Was he entitled to any credit at all?
It was 1 day credit.
Any position that you're taking?
Yeah, Judge, I think his heart condition is only getting worse. He's had some major surgeries. He's had all sorts of complications as a result of that. And we're certainly aware of the court's at least obligation to impose the 30 days in jail. But we would ask the court at this point to, in lieu of that, place him on an electronic tether to satisfy the 30-day requirement. I think that would be appropriate. I think any period of incarceration would certainly put him at risk in terms of his health and potentially even put the county at risk, because the people I've talked to seem to think that his condition wouldn't do well if he had to serve any time in the Crawford County Jail.
So,
This was Mr. Bolander's fourth drunk driving. The argument is that he's never had in the almost 2 years and 4 months a chance to serve his 30 days, which is statutory. It's not discretionary. It doesn't allow for any of the things that defense counsel is asking for. But even though his heart was so bad, he was able to operate an ORV at a 0.189. So, I'm not really sure what Mr. Bolander intends for the court to do. I mean, this is a sports drunk driving. I don't see that there's an alternative. The court ordered that he spend 30 days in jail with 1 day credit.
Judge, I would just remind the court the offense took place well over 2 years ago. So the condition that he suffers from now certainly wasn't as far along as it was, or it is now as it was 2 years ago. I mean, these aren't made up symptoms. These are real life-changing ailments that the gentleman suffers from. I think that the potential of serving time with house arrest or an electronic tether would satisfy the requirements of the statute. I think this case requires at least that consideration.
Mr. Haven, have there been any violations?
No, Your Honor, he has had no violations. He's been able to work when able. He's had downtimes where he couldn't work, but he's paid in full. He's attended counseling. He's done everything else that he needs to do, just serve his jail time.
All right, so I guess what it comes down to is two things. And Robert, you're asking that the court not impose the jail time and place the burden on your side. Number one, I think the court would need to have some kind of documentation from this doctor indicating, he would serve 30 days. And then I think I would need some kind of authority, legal authority for the court to impose something alternate to actually incarcerate.
I understand.
So you've got 5 months, right, Mr.
Yeah. Yeah, he was sentenced in October to 1.5 years.
So, Mr. Plumber, can you do that within the next 30 days?
I will do my best to do that, certainly.
And Ms. Polk, if you want to respond in terms of the legal argument, anything that's presented by Mr. Plumber as written submission to the court, I'll give you an opportunity to do that. And then the court will issue an order in writing
appreciate that. Thank you, Judge.
Thank you.
Thank you for your time.
Wilkerson, case number 245351.
Sierra Cook on behalf of the people.
Ms. Wilkerson, you come right up to the podium there, please. The record should reflect Ms. Wilkerson's presence here in the courtroom today. This is set for a status conference. Ms. Boyd, can you tell me the status of this case?
It is my understanding that Ms. Wilkerson intends to go to trial and is requesting that a trial date be placed on court.
Ms. Wilkerson, is that correct?
Yes, sir.
Ms. Coe, how many days of trial?
One.
Boyd?
Yes, sir.
And Ms. Coe, do people need any particular period of time to be ready for that?
No.
Ms. Boyd?
No,
One-day jury trial. Ms. Coe, are you anticipating any motions being necessary?
I don't think so.
Ms. Boyd?
I do believe, Mr. Durham, you requested that I ask for a final status conference.
Set this for a final status conference on the motion day prior to the trial date. Have there been any plea offers?
There was a plea offer to a domestic violence misdemeanor with a 76948 deferral in lieu of the assault with a dangerous weapon felony. Ms. Wilkerson has declined that offer and would like to go to trial on the felony charge.
All right, so the final status conference will be the motion cutoff. To the extent there are any further plea discussions, Ms. Wilkerson, the final status conference will be the last day. Enter into a plea. Decided you wanted to do that. Otherwise, the court will send out the notice of both that final status conference as well as the trial date. Ms. Wilkerson, it's important to stay in touch with your attorneys as we get closer to the trial, okay?
Yes, sir.
Ms. Cole, do you have anything further we need to address for your side?
No, thank you.
Ms. Wilkerson, do you have any questions? All right, thank you, that's all for today. It's the court's afternoon docket. The court will be in recess until 9 a.m.
Does your honor know anything